Page 4, A18-781255, Harris versus Del Casal.
Good morning, Your Honor. Kurt Harris on behalf of the plaintiffs.
Laura Ungaro for Craig Mueller's office on behalf of Michael Franklin.
Attorney Al Needham here for defendant Ernest Del Casal.
Thank you, counsels. This is a motion for summary judgment. Go ahead, counsel.
Thank you, Your Honor. I know Your Honor has reviewed all the pleadings, so I don't want to get too deep into the factual scenario, but the opposition...
I had to go back and read all of it, basically, to get an understanding and feel for it all, so I read through all the pleadings last night.
Thank you, Your Honor. I appreciate that. In this particular case, it is just a case of seller's remorse where Mr. Del Casal sold me this business, and then subsequent to that, he was remorseful about it. There was an ongoing campaign against me online that went on for quite some time, but finally resulted in September of 2018 when my Google web page was redirected to a rogue website that contained defamatory material. Now, this has been previously ruled on by Judge Baer, and I understand it's not binding on Your Honor, but Judge Baer certainly found that there was no doubt on its face that this would harm a professional livelihood, and it was certainly something that I should be concerned with. And there was no dispute that the publication contained defamatory material at that time. So with that, I did file, and which brought us here. There was a prior summary judgment motion, which was denied without prejudice. This motion was subsequently brought based upon violations of the stipulation in order, where Judge Baer, I believe, indicated on December 12, 2019, that if there were any violations of the stipulation in order not to publish, that I could immediately refile the motion and that he would sign an order shortening time for it to be heard. So here we are at this point with my motion for summary judgment. There has been a couple items that have changed at this point, Your Honor. The defendants requested that we stipulate to a bench trial. So this is a bench trial. So the argument is no longer whether reasonable minds can differ, but it's whether reasonable mind can differ, and that's Your Honor. This information is not going to change. If we go to trial, you're going to hear more information, but it is not going to be any different. Your Honor is still going to make that determination. You'll just hear more of the same of what's ongoing here. There are a couple of questions that I posed in my motion for summary judgment, which I think are very pertinent to my argument, and that is, of all things that could have occurred here, Mr. Franklin could have disclosed this so-called phantom who gave him the information to publish. But he's never done that, and he refuses to do that. He's not credible. And in fact, in his opposition, he admitted, and I quote, "The motion for summary judgment also admits that Franklin's error has been corrected. Therefore, no need for summary judgment exists." And he's essentially admitted what he has done here. And so partial summary judgment should be granted against Mr. Franklin on all cause of actions that are pertinent to him at this time. In addition to that, there's been no plausible opposition on behalf of Mr. Del Casal to this motion. It was miscited that somehow I had filed a motion to reconsider. That certainly is not the case, and it never was the case. But pursuant to EDCR 2.20 subsection E, essentially without an opposition, they would agree that this motion is meritorious. So the cause of action that I've set forth in my motion, Your Honor, for you to consider, I don't believe there's any reasonable minds can't differ that there is no reasonable dispute as to the material issues of fact. The webpage is defamatory. It contains defamatory information, and it meets the case law of Clark County School District versus virtual education, which essentially finds that a defamatory communication is one that imputes a person's lack of fitness for a trade, business, or profession, or tends to injure them in their business. And this is a defamation per se case. We're asking the summary judgment be granted against Mr. Franklin. He's admitted multiple times he is the publisher, that he edited the content, and he's admitted in his answer that he is the one who corrected his error and believes that, yeah, he's at fault. And there's no question about that with regard to his filings and his other admissions that have been made on the record before the court. He lacks all credibility, but we're asking the summary judgment be granted against him. With regard to the civil conspiracy cause of action, This was two or more individuals that engaged in a concerted action to defame an object to harm, or I guess their object was to harm an individual or harm an individual's business or their earning capacity, and it resulted in damages which are per se damages. We'd ask for we'd ask that there be summary judgment be granted on that issue as well. With regard to the theft or corporate theft, Your Honor, I think there has been some disputes as to what occurred there, but as you can see from the pleadings, the contract contemplated that this website, this web address would be purchased. That web address was never delivered. It's been evidenced that it never came into my possession, and it is evidence that it was used by the defendants for a purpose that was wrongful purpose and an intent to harm or malign and to be malicious with regard to my business practices. We're asking that summary judgment be granted on that. In addition to that, sixth cause of action, the intentional interference or business disparagement. I don't think that there's any dispute here to any of the material issues of fact. These individuals caused the legitimate web traffic to be redirected to an illegitimate site that contained defamatory material. In essence, they went on the Google webpage and they redirected the website information, and they did that without permission and for a nefarious purpose, and it didn't serve any public benefit or any public good whatsoever, and the argument can't be made. They've interfered with my business practices, and they have defamed me all the while they did that by redirecting that traffic to another area. I realize that this is a clear and convincing burden with regard to the malice there, but if you read the content and you see what was done, and you see that my legitimate web traffic was redirected for the sole purpose of defaming me, it's quite easy to see that there was malice involved here, and it didn't serve any legitimate purpose whatsoever, and it didn't serve any public purpose that they can state. Finally, with regard to the defamation per se, I believe it's quite clear that you can see on the record from looking that these individuals were certainly the publishers of this content. They certainly were the drafters. If you compare the writing style of Mr. Del Casal, the errors in spelling, the statements, the use of certain words, and I did kind of hinge my emotion a lot on typist. I don't think a lot of people in today's world use that term. Mr. Del Casal was very familiar with that term, used it very frequently, and I submitted evidence that indicated that he'd used it in the past. But for the most part, most people don't use typist, that word, anymore, and it certainly does draw it specifically to him, on top of the fact that there's information contained on that website that only he knew. And there's no question about it. And at hearing, if this has to go to trial, Your Honor, you're going to hear a line of witnesses who are going to testify that they know who the author is and that it is Mr. Del Casal. In fact, there's no question that it is him. He never served any discovery on Mr. Franklin. He never filed a cross-claim against Mr. Franklin. He never did anything to ask Mr. Franklin to disclose who this so-called phantom was. And it is very telling that his lack of effort in this part notes that he is indeed the author of the matter, and we believe that it meets the standard of proof with regard to the by a preponderance of the evidence that he is the author and that he is the one who directed that this be published. With that, Your Honor, we're asking that summary judgment be granted. We don't believe there's any issues of material fact and no reason to go to a trial in this particular matter. There's been no evidence submitted, and these parties have not produced any documents in discovery at all. And they made no production whatsoever of any documents. And with that, Your Honor, we'd ask that summary judgment be granted.
Thank you, counsel. Let me hear from counsel for Franklin first.
Your Honor, first of all, Mr. Franklin was not served in this matter until July 29th of 2019. Discovery closed on August 7th. Under no circumstance was he able to conduct any kind of discovery. He thereafter moved the court to open discovery, and that was denied. And I can't imagine why, but it was denied. And he has never had a chance to defend himself ever. He was brought into this case late into the case. Secondly, counsel, the plaintiff, is requesting summary judgment on issues that of and by themselves are not subject to summary judgment, such as conspiracy. Conspiracy is not subject to summary judgment. Case law does not allow for that. There's a question about whether there was a conspiracy. There's a question about every fact in this case, as a matter of fact. The questions are that, first of all, Mr. Franklin is in the business of building websites. That's what he does for a living. He buys and sells websites. He was going to be retained by somebody who apparently noticed that the website that was being used by Equal Rights for Divorced Fathers was no longer being used, and decided that he was going to utilize that, was going to retain Mr. Franklin to post, or to create the website, actually, to build the website and to post content on it. And as he does with every single solitary client that he has, he created the website for the client's approval. Client did not come back, did not make any, didn't come back about it at all, and certainly didn't pay for it, and their website was removed after 24 hours. Now, Mr. Harris is saying that that is not happening, that that did not happen, that there's continuing violations with regard to this, and while we object to that because there are no violations whatsoever, that is a question of fact, whether that actually happened or not, and therefore is not admissive of summary judgment. Secondly, or thirdly, intentional interference is always a question of fact when we're concerning intent. Whether this was redirected in the normal course of building a website and posting a website and owning a website, these are all factual issues. And again, Your Honor, this defendant has not been given the opportunity to have any discovery, to do any discovery whatsoever. Also, defamation is subjective by nature. Again, not admissive of summary judgment. It's always a question of fact.
Counsel, what does defamation per se mean?
Are you asking me?
Yes.
Okay. On its face, defamation per se, that yes. It would appear to be defamation, that it's a defamatory comment, a negative comment.
That sounds like defamation. That sounds like the definition of defamation. What's the per se part?
Well, Your Honor, I'd have to check and get you a good definition of it.
Okay. Let me hear from Del Casal, his attorney.
Your Honor, this is Attorney Al Needham for Mr. Casal. You know, my first, when I received this second motion for summary judgment, obviously my first concern was this has already been heard before. In fact, it's already been decided before, so I was concerned why we're here again. So, as you know, the local rules indicate if you're looking for a rehearing, you have to do so properly. And I pointed out in our objection to this, you know, rather than go through this hearing one more time, I point out an objection that as you can see, the scheduling order puts deadlines on filing dispositive motions. That has passed. And as I just mentioned, the local rules indicate you're not allowed to seek just rehearings whenever you want to. There's specific standards in place. You have to have new information. In this case, it's essentially an identical motion. That's my position, and I think it was improper just to bring it again. That's my position. But it's a good opportunity because Mr. Harris admits, and it's established that Michael Franklin's the one who published the website. And that's a key element to defamation, so it's impossible that Mr. Del Casal should be released and plaintiff should drop his claims against Mr. Del Casal given the admissions on the record. In regard to theft claims, that sounds like a criminal case. That's not proper for this court, theft. We have a concern with that. I agree with co-counsel that civil conspiracy is normally not proper for summary judgment. And in regard to discovery, the plaintiff, Mr. Harris himself, has not presented any discovery dispute in front of the discovery commissioner. If he's concerned that Mr. Franklin hasn't responded to his discovery prompt, you're supposed to go to the discovery commissioner. But Mr. Harris hasn't done that. He hasn't taken any depositions in this case. On the other hand, Mr. Del Casal has done good discovery on this case. In fact, we submitted written discovery to Mr. Harris and just some basic questions about his case against Mr. Del Casal, and Mr. Harris' responses were, well, discovery's continuing and we don't know right now. I attached that to the previous proceeding in the summary judgment or oppositions. You can see for yourself Mr. Harris's responses, and he didn't provide anything. So we're very concerned at this point of Mr. Harris's continuation of his claims against Mr. Del Casal. His continuation of his claims against Del Casal, I don't believe is proper. It's based on suspicion. Mr. Del Casal, by the way, has not been heard at all in this court. On the other hand, Mr. Harris is speaking directly to the judge and testified probably 3 times. Mr. Del Casal has not had an opportunity at all, has not had an opportunity to speak to the judge. But the claims against him should be dismissed. In regard to the court's question on what defamation per se is, that's defamation in regard to specific instances, such as if you make allegations against a business or trade like Mr. Harris, or in regard to crime, allegations of crime. It's kind of a limited set of questions. But in this case, Your Honor, we're dealing with a negative review on the internet. Those are done every day. And they don't allow for lawsuits. If you file lawsuits and open the floodgates, and now every time you get a negative review, you can just file a lawsuit against somebody, that we're going to have, it's just not right. So this case is about a negative review. That's all it's about. And Mr. Harris has made, in my opinion, no effort to resolve it whatsoever. Just filing motions. Before you file a motion, if you have any concerns, make a good faith effort to resolve the matter. That's what you're supposed to do before you file a motion to compel in front of the commissioner. Just send me a letter and try to resolve an issue. If you feel a temporary restraining order has been violated, make an effort to reach out to counsel before you file a motion. I'll end it at that, Your Honor. I believe the claim should be dismissed against Mr. Casal based on the admissions on the record. He's not the publisher. In fact, Mr. Franklin has said himself that Mr. Del Casal is not involved. What more do you need to drop the claims against Mr. Del Casal? That's it for me, Your Honor. Thank you.
Okay, thank you. Let me hear a reply.
Thank you very much, Your Honor. And I'll try to be brief. I'm not really sure where counsel is coming from with this. It's just a negative review. The rejection of the web is a hostile effort to damage someone's business and then to redirect them to a fraudulent 10-page it's manifesto of anger and remorse, contrary to me and others that work for me and family members. So I'm not really sure how that becomes a negative review or how that becomes somehow it's okay. With regard to the settlement negotiations, I don't think those are appropriate at this time, so I won't address those. It appears as though there is an admission that Mr. Franklin is in fact liable. There is a conspiracy case there. That is why Mr. Del Casal is still in the matter, because he did conspire with Mr. Franklin to undertake the actions, and he is the author of the defamatory material. And I believe that all the evidence will establish that, Your Honor, and there really isn't any question with regard to that. In answering to Mr. Franklin, he didn't appear at the 16.1 Joint Case Conference. He was served with discovery, which he answered. He served his own discovery. I'm not sure where counsel's coming from, saying that he wasn't allowed to participate in discovery. He didn't request any extension of time. He made no effort whatsoever to participate like that. And the only time he did make a request, it was well after the close of discovery. And so that's the reason that Judge Bear, again, denied his untimely request, because it was long after discovery had closed. And he made no effort whatsoever prior to the close of discovery. With that being the case, Your Honor, I do believe that summary judgment is appropriate. There's no reason to waste the court's time and to persist in this. It is quite clear on the record. And again, there have been substantial changes since the filing of the prior motion for summary judgment a year ago. And again, I thought I had touched on those and noted those, but this is a bench trial now at the defendant's request. And if you look at Judge Bear's prior ruling, all that was predicated on the fact that a jury would be making the determination of the decision at that time, and not Judge Bear. And again, Judge Bear did make the invitation to file this motion. I did file it in his court. I did request an order shortening time. It was not signed, but the record is quite clear on that he did make that invitation if the stipulation and order were violated, and I did submit that evidence. So thank you, Your Honor.
Thank you, counsel. I'm going to go back and pull the procedural timeline. I read through all of the pleadings, but I want to get a procedural understanding timeline-wise as far as what was going on and what discovery, if any, was done after the original MSJ, and what was available to the parties at the first MSJ that we're now saying, quote unquote, is available now that wasn't available before. That's what I want to get an understanding of, because that's where it really comes down to me when people file a second or third motion, is basically what's changed, what circumstances have changed to grant the authority for the court to basically revisit an MSJ. I'll have an answer to you by the end of the week. Thank you, counsel. Please stay safe.
Thank you.
Thank you.